Chapter 49. Partnership Bills Analysis. Section 936. In general, suits for dissolution. Courts of equity have a wide jurisdiction over partnership affairs, arising out of the peculiar relationship between the parties. Thus, where there is a demand existing in favor of one partnership against another, both having a common member, there can be no remedy at law, for one party cannot be both a plaintiff and a defendant. In equity, however, this can be adjusted and justice done. The commonest bills are those for a dissolution and for an accounting. A bill of the former class generally includes the latter, but the converse is not true. A partnership may be dissolved in several ways without the interposition of the courts. Such matters, however, are beyond the scope of this work, and for their discussion, the reader must be referred to treatises on the law of partnership. There are cases in which the aid of a court of equity is needed in order to work a dissolution, and when the facts show the necessity and right of one party, equity will take jurisdiction. Thus, where one partner has abused his trust, as, for example, by misappropriating funds, or by excluding the other, equity may interfere to decree dissolution. And such relief may be proper when it is impracticable to go on with the business, and when the disagreements and disputes between the parties have become so violent and lasting as to prevent any beneficial results from the continuance of the connection. Where a person has been induced, by fraudulent representations, to enter into a partnership, equity may rescind the contract at his instance, and put an end to it ab initio. Upon determining that dissolution is proper, the court will proceed to administer the affairs of the partnership, ordering an accounting, the payment of debts, the disposition and distribution of the property, and a settlement of balances. To accomplish these ends, a receiver may be appointed, and an injunction may be awarded to prevent the partners or others from interfering in their settlement of the partnership affairs. Section 937. Suits for accounting. Legal remedy. When a dissolution is sought or has occurred, equity has jurisdiction of an action to compel an accounting of the partnership assets. There was originally a remedy by an action of account at law, but the superior advantages of the equity procedure have caused the legal action to fall into disuse. The main superiority of the equitable remedy lies in the fact that the complainant may compel a discovery of the items of account. The legal action was not maintainable when there were more than two partners. Consequently, in such a case, the remedy in equity is, and always has been, exclusive. Section 938. Same dissolution necessary. In general, a court of equity will not interfere to order an accounting, unless a dissolution has occurred or is sought by the bill. The reasons given for this rule are that interference will tend to strife, which will lead to a dissolution, and that it is impracticable to take an account of the affairs of a going concern because they are constantly changing. It is not the province of equity to enter into a consideration of mere partnership squabbles. Such matters should be settled by the members themselves. Where there has been a dissolution, however, or that relief is sought by the bill, these reasons do not apply, and it becomes the duty of equity to see that justice is done to all parties. It seems to be the rule that no demand for an accounting need be made before applying to the court. Section 939. Exceptions. Accounting without dissolution. To the rule stated in the preceding section there are several well-defined exceptions. Bearing in mind the reasons given for the rule, it will be seen that cases may arise in which neither will apply. A leading text writer mentions three classes of cases as exceptions to the general rule. 1. Where one partner has sought to withhold from his co-partner the profits arising from some secret transaction. 2. Where the partnership is for a term of years still unexpired, and one partner has sought to exclude or expel his co-partner, or drive him to a dissolution. 3. Where the partnership has proved a failure, and the partners are too numerous to be made parties to the action, and a limited account will result in justice to them all. To this classification must be added the class of cases, 4, where the agreement of partnership contemplates settlements of distinct transactions, or at stated times. Section 940. Who may bring suit? The general rule is that anyone who has a direct interest in the partnership settlement, and who is not otherwise represented, may sue for an accounting. Clearly, a partner comes within this class, and his right is admitted. An assignment of the interest of a partner merely transfers his rights after an accounting and settlement, and consequently the assignee is entitled to compel an accounting for the same reason. A purchaser of one partner's share on execution may maintain such a bill. The administrator of a deceased partner is the proper party to sue on behalf of the estate. The heirs are not allowed to sue, even though a conspiracy between the administrator and the surviving partner is alleged. They have a sufficient remedy by application to the probate court to remove the delinquent administrator, and if any loss has occurred by virtue of his negligence or wrongful acts, redress may be had in a suit upon his official bond. Employees who, in payment for services, are entitled to a definite share of the profits, may also maintain the bill. Without such accounting, it would be difficult, if not impossible, to establish the claim. Section 941. Grounds for refusal of relief. It is no doubt the general rule, when a partnership is alleged and admitted, to order an account as a matter of course, unless the right of the complainant to relief is barred by lapse of time. But where it manifestly appears from the proof, that the party asking the interposition of the court has no real cause of complaint, and that no good purpose or end can be accomplished by directing an account to be taken, it ought not to be ordered. Accordingly, it has been held that no account will be allowed when, for any reason, it is unnecessary, as where complainant has access to the books, which contain no complications. No relief will be given to an absconding partner who seeks an accounting, the denial being based upon the maxim that he who comes into equity must come with clean hands. Section 942. Statute of Limitations, Laches. It is the general rule that bills for partnership accounting are subject to the operation of the statute of limitations. Where such actions are not expressly mentioned in the statute, the courts will act by analogy to the legal rule, and impose upon the remedy they afford the same limitation. In many states, the statute is made applicable to proceedings in equity, and in such jurisdictions the courts apply the provisions directly. While there is little dissent from the proposition that the statute will be applied, there is a great diversity as to when the period begins. In cases where the partnership is dissolved by death, the general rule is that the statute begins to run from the death. The courts adopting this rule hold that the surviving partner is not a trustee in the technical sense, and that accordingly the rules as to trustees do not apply. Upon the same theory, the time, in cases of dissolution otherwise, should run from the date of dissolution. In some jurisdictions it is held that the statute does not begin to run until the debts due to and by the partnership are paid, in some, that it runs from the date of the last item on the books, and in others that it runs from the time the partnership accounts are settled and the balance is struck. As in all equitable actions, the doctrine of laches is applicable, but mere delay short of the statutory period of limitation will not bar relief. Where the partners fail to keep books, or fail to keep such books as will show the status of the firm's affairs, and they postpone a settlement till one of them dies, or till important witnesses die, or till necessary records are lost or destroyed, equity will not interfere to relieve such misfortune. Section 943. Disposition of partnership property upon dissolution. Upon a partnership accounting, the firm debts must be paid before any distribution can be made to the individual partners or to the representatives of their interests. To pay such debts, all of the partnership property, both real and personal, may, if necessary, be sold. After the debts are paid and the rights of the parties are determined, the property should be distributed. In England it is held that all of the property must be sold, and the proceeds divided, unless there is some agreement to the contrary. In America this rule applies to personal property, but there is a conflict of authority as to the realty. The better rule seems to be that a partner may compel a partition of the realty. If that is possible, there is also a conflict between the English and the American rules as to succession to partnership property. In England, both real and personal property descend as personalty. In America, the property descends according to its true nature, the personalty going as personalty and the realty as realty. This prevails even in some jurisdictions where the right to a partition is denied. Section 944. Rights of creditors in partnership property. The interest of an individual partner may be reached by his creditor, and may be sold by him under execution. In levying, the sheriff may take actual, manual possession of the property, and he may do the same under an attachment before judgment. By the weight of authority, the partner whose interest is levied upon, or any of the other partners, may come into equity to have an account taken before sale, and to render this right effectual, the sale will be enjoined. And it has been held that a partner against whom an execution issues is entitled to an account even after the sale is made. It must be borne in mind, however, that it is only the individual's interest that is sold. A party coming in the right of the partner comes into nothing more than an interest in the partnership, which cannot be tangible, cannot be made available, or be delivered, but under an account between the partnership and the partner. And it is an item in the account that enough must be left for the partnership debts. Each partner has an equity to have the partnership debts paid before the property is distributed. Section 945. Rights of creditors in separate property. It was settled at an early day in England that when equity has jurisdiction over firm and separate funds, the joint creditors shall be first paid out of the partnership or joint estate, and the separate creditors out of the separate estate of each partner. And if there be a surplus of the joint estate, beside what will pay the joint creditors, the same shall be applied to pay the separate creditors, and if there be, on the other hand, a surplus of the separate estate beyond what will satisfy the separate creditors, it shall go to supply any deficiency that may remain as to the joint creditors. This is an application of the equitable doctrine of marshalling assets, and so far as it gives priority to separate creditors, it has been justly criticized as an arbitrary rule. It must be remembered that it is not a legal rule, for at law a firm creditor may by attachment or execution acquire a priority. While the doctrine is primarily equitable, it is most frequently applied in bankruptcy and in proceedings for winding up the estate of a deceased partner. In its general scope, the rule is supported by the weight of authority in the United States. An exception allows firm creditors to prove against the separate property when there is no joint property, and there is no living, solvent partner within the jurisdiction. In probate proceedings upon the estate of a deceased partner, the same rule of distribution applies. In America, it is generally held that the remedy against the surviving partner must be exhausted before firm creditors can resort to the estate of the deceased partner. In England, however, this is not necessary.